Hi. In continuation of my analysis of the recent judgments of the Honorable Supreme Court in IBC matters, today I am analyzing a judgment whether all dues under a statute are government dues or not. So this is a reportable judgment of the Honorable Supreme Court of India in Paschimachal Vidyut Vitaran Nigam Limited for the appellants versus Raman Ispat Private Limited and others respondents, civil appeal number 7976 of 2019. The facts of this case in brief is that corporate debtor had defaulted in the payment of the electricity bills. As per the agreement, the outstanding dues will create a charge on the assets of the defaulter, that is CD herein. NCLT Ahmedabad bench ordered for the releasing of the property in favor of the liquidator to enable him to sell the same in liquidation. Though the company had went against that order, NCLT had dismissed it again and resulted in this current appeal. So what was the decision of the Supreme Court in this particular matter? IBC, bench had analyzed that IBC was enacted with the objective of unifying the legal regime of corporate and commercial insolvency. Adjudicating authority has no jurisdiction to interfere with the commercial wisdom of the committee of creditors. It observed that if CIRP fails, liquidation is a fate. We cannot avoid that fate. So, with respect to the payment to the secured creditors, the bench had observed that during the CIRP stage, secured creditor is not permitted to initiate the proceedings to realize its dues due to the existence or operation of a moratorium under section 14 of the IBC. Secured creditor, due to that reason, is precluded from bringing any action to foreclose, recover or enforce any security interest. So there is a restriction on the on the financial creditor who is a secured creditor at that stage. Secured creditors' rights are restored only in the event of the failure of the insolvency resolution process and commencement of the liquidation proceedings. So during the liquidation, the distribution is happening in accordance with the provisions of section 53 of the code. If a secured creditor relinquishes his security interest, a high priority shall be given to him at the time of distribution. If the secured creditor is not relinquishing the security interest, his priority will be lower in level. The secured creditor has to take a calculated decision with respect to the relinquished security at the time of liquidation. So, bench had also analyzed its judgments regarding the treatment of the government dues. So, government dues are basically not defined under the IBC, though it is mentioned under the preamble that any amount due to the central government and the state government, including amount to be received on account of the consolidated fund of India or a consolidated fund of the state, is noted as a government dues. So government dues is ranking lower in the waterfall mechanism because in the preamble of the act itself is stating that one of the main objective of the court is to alter the priority in settlement of the government dues. So all dues owned under a statute are not to be treated as a government dues. This is a departure from the finding of the Honorable Supreme Court of India single bench in Rainbow Papers Limited. We will come to that. Dues payable to statutory corporations are not government dues. Such dues may be an operational debt or a financial debt. So dues payable or requiring to be credited to the treasury, such as tax, tariffs, etc., are basically government dues. So the Honorable Supreme Court of India brought a clarity on this matter. So court in this judgment has observed that State Tax Officer versus Rainbow Papers Limited at 2022 single bench judgments had failed to take notice of the waterfall mechanism under section 53 while passing that judgment. Dues payable to the government are to be placed much below the dues of the secured creditors and even unsecured creditors or operational creditors, which was actually departed in that particular judgment in an erroneous manner. The Rainbow judgment, failed to take note of the provisions of the code which gives lower priority to the government dues. Though the charge is created as per the Gujarat Value Added Tax Act 2003, state is to be treated as a secured creditor. By this, the Supreme Court of India had brought clarity to the much ambiguous judgment in case of Rainbow Papers Limited. So final decision in this judgment was that in view of the analysis made, the PVNNL, that is the bank, the electricity board, is to be treated as a secured operational creditor due to the charge created on the assets of city. The term used is secured operational creditor. Though PVNNL, that is appellant herein, has the government participation in its holdings, it does not render it as a part of the government, and dues and amount payable to the PVNNL, that is appellant, do not fall within the description of section 53 subsection 1 clause F of the IBC. So thank you very much for the patient listening.